All right, we apparently have another meeting in this room at 12 o'clock, so we're gonna go ahead and get this thing started. Can everybody in Zoom land hear me? Somebody can maybe chime in just to make sure we're getting some audio.
Yep.
Yes.
Is that a yes? Okay, awesome, thank you. All right, so if you don't know me, my name is Doug. I'm your esteemed broker. I'm also on the state forms committee, so I was a part of some of the discussions for the new contract changes that rolled out this year. Fortunately, we are not dealing with a 2022 situation where they changed everything around, right? This is more about streamlining and tidying some stuff up. So in fact, we'll kind of notice a little bit of a trend here where a few of these are just forms that were referenced in the contract but not previously provided. So now we're just trying to provide the forms that Amanda said they were already providing. So here are all the new forms at the outset. And we'll just go through them one by one and make sure there's no technical problems with chat. Okay, perfect. Okay, so the very first one, we're providing for the first time a commercial buyer representation agreement. So this is only in the commercial space. Last year, they started providing a listing agreement in the commercial space. So this is now just providing a buyer agreement to correspond with that, okay? So these are the only commercial forms for which MAR has provided a template, and it's just a brokerage agreement.
Question.
Yeah.
First question of the day.
Yeah, thank you, Mark.
You know, on a residential side, as a realtor, we have to use the buyer agency agreement provided by MAR.
Yeah.
And sales contract
Yes.
provided by MAR. Is that the same now? If you're a member of NAR, do you have to, if you are representing a commercial client, do you have to use that agreement, or can you use an agreement that had been previously or not previously written by one's own attorney?
That's a great question. Thank you, Mark. I don't know that I was part of any discussion about that. My presumption or my gut is telling me that if you had an attorney draft it, you can use that, especially in the commercial space. I think this was, the intention behind this at least was to prevent people from just kind of drafting up their own document willy-nilly. And if people were already doing it, let's at least give people a tool to do this correctly. Now, this is also not a very exciting document. This is basically identical to the existing residential buyer agreement, but it has the word commercial and it says, hey, don't do this if you're not qualified.
Okay.
So that's a great question. I can't imagine they could penalize you for not using their forms. I think it's more
Well,
about.
they do on the residential side, right?
Yes, so it's a good question that I will get clarification on. So again, this only impacts people that are doing commercial stuff. This is only the representation agreement. After you get them under the agreement, anything else, your letter of intent, your contracts, please work with a qualified attorney that's going to help you with that stuff. Because MAR does not have any interest in providing those templates beyond just the listing and buyer representation stuff. Okay. This next one stresses me out a little bit. This is again an addendum that was referenced in the contract but didn't exist before. So we're like, okay, we referenced it before, let's have MAR go ahead and give it to us. So this is an awesome concept, but a really complicated execution, right? So an assumption is when you take over somebody else's loan. So as a buyer in this market right now, heck yeah, I want to assume the loan if I can. I want to take their 3% loan instead of getting my new loan at 7.3 or whatever it is. So this addendum is meant to basically set forth the framework that's going to let you start that process. Okay, so let me jump in so we know what we're looking at here. Okay. So this new assumption addendum, basically the seller is going to set forth the current loan terms. This is what I owe, this is the interest rate.
Why do you think this is coming out now?
Honestly, I think it was just caught in it was referenced in the contract, but wasn't previously provided. So, I mean, there's a couple of arguments for that. I think it probably isn't appropriate. There will be a greater demand for it, for sure, in this exact market. I don't know if that actually triggered it or not, because this is still really, really complicated and kind of a scary thing to make a standard form, if we're being honest.
Right.
So the important piece here that I want to kind of highlight is that the buyer still needs to be approved for this assumption, right? So now instead of the buyer going out and getting their own loan with their own loan officer, the seller's lender basically has to step in. So there's going to be some time frame by which the seller needs to get certain qualification materials over to the buyer, and then the buyer needs to fill that stuff out. Now, importantly, if the buyer is not approved within X days you put in, then the buyer can get out of it, right? So there is a universe where me as a buyer would go in and say, hey, I'd really like to assume this loan, but if I don't qualify for it, you can't make me buy the house. But it's also contemplated that you could then pursue alternate financing. So it doesn't necessarily lock you into anything. So I think that is at least contemplated there. If there are additional fees, let's say the lender doesn't want to give the new buyer the 3% loan, but maybe they'll do a 5% loan or something like that. There's language in here to sort of negotiate those things and not put the buyer on the hook. If, let's say, you know, the seller's lender is suddenly only willing to give them a 7% loan, then they would have the opportunity to terminate that contract. The other piece that stresses me out about assumptions is that it's not clear whether or not the original seller is actually off the hook for the loan, even if somebody else is making the payments, right? So section 3 here is really important. So the seller will need to decide. And if I'm the seller, I'm not touching this with a 10-foot pole unless I'm getting a written release from my lender. Because I don't want this guy's default to come back on me, right? So it may be clever for a seller to say the contract is conditional on the seller being released from liability on the existing loan. So if I'm giving this loan to the buyer, I want out personally. If there's a difference in the loan balance, the seller may need to bring that up. And my favorite part and then if it's a VA loan, there are certain forms that have to be used. So this just sets that forth. So again, this is really more of a proposal. Hey, I'd really like to assume this. Then the seller needs to go to the lender. The lender needs to decide whether or not it's assumable at all. They need to decide if the buyer is qualified for the assumption. They need to decide if the original seller is going to be released from liability, and all these trigger points could just blow up the assumption completely, right? So there's in a lot of instances it's not going to go through, in which case they'd have to pursue other
timelines in place in this document that give us time to really just like a
so in each that's basically what all these blanks are for.
okay.
So you'd fill it out. So you have X number of days for the seller to provide application forms. If the buyer's not approved within certain days, the buyer can terminate. So you just have to really go through, read everything carefully. And it does contemplate various trigger points where you can get out of the deal. So it's a great idea in theory. I'm all about it. Just make sure you're sort of setting expectations clearly. Just because this form is here doesn't mean that your buyer is going to qualify for an assumption automatically, right? It is my hope, and I've sort of heard anecdotally that lenders are starting to get more creative with this because there's so much demand. I mean, buyers would much rather assume a 3% than take out a 7%. So I think there are lenders out there that have some experience doing this, but just a lot of things need to line up, right? So it's a helpful tool. It's going to help keep you out of trouble if your buyer is really interested in pursuing the assumption, but I wouldn't necessarily throw it out as standard fare.
So
Doug, I have a question.
if
Oh, 1 second. Yep, go ahead.
if we do offer this, or we talk to our clients about
Mm.
this, then how does that work in relation to the question in the contract of financing, like the days? Is that included in those days that we do at the beginning, like 7 days for contract or for an application, and then 21 days for loan commitment or whatever it is? Do you know what I'm talking about?
I do. So,
Because it seems like this would take a lot longer than just getting a pre-approval.
yeah, I think this would basically supersede that, and we're gonna have to kind of work through maybe a test case so that we understand exactly how they interplay. But I think this would kind of be the first step, and then if it doesn't work out, section 1.2, you can pursue alternate financing per the terms of paragraph 23, and then that would trigger those timelines, I think.
Okay.
So I think this would be kind of A, and then it would go down to B. But if this is something you're contemplating, we need to kind of go through all the different iterations of
So
the
if this is
example.
something that actually becomes where people are interested, then
Yeah.
definitely go a little bit deeper into.
Yes, we
Okay.
sit down and make sure that we're crossing our i's and dotting our t's.
Okay.
Did I get a question from Zoom land?
Yes, I had a question. This is Brianna.
Okay, I can really only barely hear you, so let me see if I can figure, maybe you're on the TV. All right, can I hear you any better now? Go ahead.
Hello?
Hello? Yes, all right, perfect.
Really quick, whenever it talks about the difference in loan balance, but it says that the seller shall cover any net difference between the approximate balance owed on the existing loan as shown in section 1. So in that statement, what exactly when would that even be applicable, if that makes sense? That the approximate balance owed and the actual balance is different. Like, what does that mean? Like the balance that's advertised is different than
Exactly. That's my exact interpretation, Brianna, that you can't advertise that you only owe 200,000 if you actually owe 300,000, right?
Okay.
So then you sort of materially misrepresented what you owe, then the seller is responsible for the difference. So I would say when you're filling out part 1 on the seller side, that needs to be like a final payoff provided by your lender, not like something you've estimated, not something you've just looked at based on bank statements, right? Like I want an official payoff just to protect your seller from that paragraph 4. That's a great question.
Okay, and then one more, sorry. So if because typically whenever you're assuming a loan, the seller is still selling in order to get a profit, right? So they're usually selling it at a higher price than what the loan balance is. So how does the buyer, is there no part of this that covers the buyer obtaining financing for that remaining whatever that difference is? Because that's usually what happens, right? They have like a $250,000 loan, but they're selling for $300,000. The buyer's assuming the loan to get that lower APR rate, but what about that that $50,000 difference? Is the buyer just having to come to the table with cash on that?
I think this doesn't contemplate that transaction. So however you've been doing that transaction in the past, you'd still do it. But this would help make clear the obligations for the assumption part. So you're talking about kind of a 2-part transaction.
Right.
I'm going to assume this loan and I'm taking out a new loan for X. This nowhere in this document does it contemplate that new loan that I can see. This is just for the assumption part. So you're right, in the situation where we're talking about an additional loan on top of that, that's when you're triggering what Melissa was talking about, where there's a new financing contingency, basically, because I assume the buyer wouldn't want to buy the house if they don't qualify for the balance loan, correct?
Right.
Yeah, so there's a lot more to that. So I think we would need to use a combination of this document and a traditional contract of sale with some language kind of doctoring it up, explaining what's happening. But yeah, you're absolutely right. I think that's the practical application, and it's not really contemplated here. I think this is in some respect. See here, our contract referenced an addendum, but didn't exist, so now it exists. But that doesn't mean that it's all that helpful. I guess
Right.
is one that we just learned. But yeah, I think there's ways to figure that out, but that is not expressly contemplated in this document.
Okay, thank you.
Yeah, of course. Okay, the next new addendum, which was again referenced in the contract but didn't exist. Has anybody dealt with a FERPTA issue before? Does anybody know what FERPTA is? All right, FERPTA, the Foreign Investment Something Property Tax Act, is basically a way for Uncle Sam to make sure that a foreign seller pays income tax. Has something to do with capital gains not usually being taken for foreign investment. And this law has been in place forever as far as we're concerned, right? So this is not changing the law. This is just a notice that is going to be required to be provided for certain sellers. So if you have a seller that is a foreign person, as defined by the IRS, and the property is more than $300,000, this is a new disclosure you have to put forward. Okay, so that's nuts and bolts, the only thing that you guys need to remember. If you have a foreign seller, it could be an LLC from Germany, it could be someone who's here but doesn't have a green card, it could be any number of things. If that seller is putting a listing on Bright, you need to include the FERPTA addendum. Okay, what the FERPTA addendum, really all it does is put out there, seller is a non-resident alien, foreign corporation, FERPTA applies. Section 2 only really matters if, like, yeah, we know FERPTA applies, but we already know that we're exempt. We have this certificate. You have some certain number of days to provide that certificate. Here's my favorite part about this addendum. Seller and buyer understand that brokers, their agents, sub-agents are not experts regarding FERPTA, and seller and buyer are encouraged to consult with their own legal or tax counsel. This is an extremely messy law that is very confusing. When this is implicated, you need to talk to your title person immediately because they actually sort of know how to handle this. Basically, how it works is that the buyer is responsible for withholding some amount of the seller's proceeds and it be sent to the IRS, and then the seller can go back to the IRS to maybe get some of that back. So it's a really complicated maneuver that it says right here, we're not experts in, but I think this is great because if it's a disclosure, we're going to know about it sooner and we're going to be able to have that conversation with our title people right off the jump. So there's not going to be any last minute scramble when we realize there's a FERPTA issue, right? So it's all going to be out there and then we'll just be able to handle it. So again, this doesn't change the law at all. It's already been in place. The fact that none of you knew what this was is great because hopefully it still won't impact you, right? But this is a disclosure that we're going to have just to make sure everything goes more smoothly. Okay, this is another fairly limited use disclosure that was referenced in the contract but didn't exist, so now it exists. This is a disclosure that a seller will have to provide, but it only goes into effect if there is a forest conservation plan. A forest conservation plan will only be in effect if it is a pretty big property, an acre or more, and there was some big application for subdivision grading, something like that. So hopefully your seller would know if there's a plan like this in place because maybe they subdivided and had all these trees cleared, and then there's this forest conservation plan that they already know about. So again, we only have to provide this if there is a plan in place.
Does this replace the conservation easement addendum? Or
No,
is
this
it used
is-
in conjunction with?
This is in conjunction with, it is a very specific to the forest conservation plan, which is not contemplated in the other addendum, I think. Yep, and then it basically works, it's almost like an HOA notice then, where the forest conservation plan needs to be provided to the buyer. If the buyer says, hey, I don't like any of this, I was trying to use my property for this function and it won't let me under this plan, then they have a way to get out of the contract. So again, this probably won't impact you very much, but if your seller has a forest conservation plan, they need to provide it as a disclosure, and then it provides a potential contingency for the buyers.
And that would be something that they would have, like, we would have to find that on.
No, to my knowledge, you know, it's something where you'd always kind of check the land records to see if there's anything funky. But I don't think we can promise anybody that it's gonna be there. So it really is something where we rely on our sellers to let us know. Okay, here's the other one that stresses me out. The owner financing contingency addendum. Again, this was referenced in the contract, didn't exist, and now we're giving it to you. So for people that work maybe in the investment space, or owner financing has already been happening, right? That is when basically your seller is now also the lender, and instead of you getting your own loan, you basically pay them for the house that they're giving to you. Note, this is a complex transaction governed by many state and federal laws. Real estate brokers are not qualified nor licensed. To make sure that we're in compliance with these laws, members are encouraged to advise their clients to consult with competent legal professional.
Who is the competent legal professional? Like that?
Not me.
Like, I don't care, it's
Does
not me.
you say I would talk to an accountant about that? Like, who would you?
No, it would be, it's very likely the same sort of attorney that you would go to handle a commercial deal. It would be somebody, because you're literally drafting loan documents here. And that's why, so this is really like, a statement of intent is probably not the right term, but this is the proposed outline of what we would like the loan to be, right? So this is just kind of putting it out there. Okay, I'm interested in owner financing. The owner would say, okay, here would be the terms of the loan. The owner as lender would then have an opportunity to get your financial information in the same way that a lender needs your W-2s and your taxes and all that stuff. The owner would get that stuff. They would have an opportunity to cancel after they review your finances and realize that maybe it's not a good idea. And then to make perfectly clear, you know, the credit documents, i.e. the loan documents, such as the note or deed of trust, obviously needs to be drafted by a competent attorney. And I don't think it's crazy complicated. It might only be a few $100s for somebody to kind of do a boilerplate note and a deed of trust. But that is risk that needs to be offloaded from you and from the brokerage, because this is not real estate practice anymore. This is loan stuff, right? And we are not lenders. So it says here, by default, the seller is responsible for the creation of the loan documents. I guess that's negotiable. You could cross that out or figure out if you wanted to split it or something like that. And then there are deadlines contemplated here. So this is really just the proposal, right? Hey, I would like to do X. I'm going to give you my documents. If you don't like it, you can cancel. As you propose an interest rate and loan documents, I get to review the documents, figure out if I want to cancel. So again, this has already been going on. To Mark's earlier question, I'm going to need to figure out, let's say you already have an owner financing addendum that you've been using. I'm not sure if MAR is requiring you to use this one or if you can still use what you were doing. So I'm going to get some clarification there. But it's a great tool if it's something that you have a buyer that's interested in pursuing. If he listens to a podcast and says, I want to do owner financing. It's say, oh, well, let's walk through this, figure out what would be a reasonable term. What would be reasonable terms, and then you. But you need two to tango, right? The seller needs to be okay with not only selling their house, but operating as bank, right? So it's a fairly limited universe where this is going to apply, but it's a helpful tool to have. Okay, the next one is actually going to be somewhat useful for people. There are a whole bunch of sellers out there, right, that will be happy to sell their house, but only if they can find a new house, right? So this is the seller's home of choice addendum. It looks an awful lot like what we currently have for the buyers, which was called the sale, financing, settlement, or lease of other real estate addendum. So let me show that to you.
Seller's home of choice.
So this may look similar to what you've already seen, right? So this is the seller saying, I'm willing to sell this to you, but only if some of these things happen, right? The seller can basically mandate that 1, 2, or 3, or all of these need to happen as a contingency for the contract. So the seller might say, okay, I'm willing to go under contract, but I'm going to cancel if I'm not under contract by X day. Or I'm going to cancel it if I don't have my financing will be final. Or they might say, look, I'm not selling you anything until I close on my next house. If I don't close and actually get that money, have a place to live, I'm not selling you the house. So it looks exactly like what we would use on the buyer side, where they're saying, hey, I'll buy, but only if I sell. This is, hey, I'll sell, but only if I buy. Yeah.
No, but what is that? 2 on C? Execution of a written disagreement for 2 on C.
Right, so part C sort of contemplates, say, look, even if I don't settle, so long as I at least execute a lease by this date, I'll still sell you the lease. Sort of thing.
Okay. So
Yes,
that's if
this-
somebody who's trying to buy a house, but they're selling their house at the same time.
Exactly, yeah, so this is the seller's home of choice addendum, so this is where the seller is saying, all right, I'm putting my house on the market, but I can cancel the sale if I don't find a place. So that's what this would be for. Yeah,
So
Julie.
this is another thing that you add into the contract.
Correct.
At the bottom where it says all timelines shall begin when the seller removes these contingencies upon the deadline, whichever, or upon the deadline, whichever is earlier. Does that mean that none of the inspections, anything to begin, and does that include EMD timeframes? Because typically an EMD would be needed to at least have a contract sale, kind of have weight, right?
All timeframes in the contract shall begin when the seller removes these contingencies or on the deadline.
Like, I don't have to pay, as a buyer, I don't have to pay for inspections or make deposit my EMD or essentially do anything until you tell me that you found it on your voice, and then that's when my timeframes begin. And then it doesn't state that the removal of the contingency needs to be written notice or anything like that.
It's as if you've had these problems with the buyer side of the same document.
Well, it kind of reminds me of like third party approval, right? Like I have to show written approval and I have that opportunity in the contract to say either my timeframes begin when the contract is ratified or my timeframes begin upon receipt of written notice of third party approval. But I'm just questioning whether timeframes includes EMD deposit, it's those other contingencies, quote unquote.
Yeah, I mean, all timeframes in the contract is pretty darn broad. I think the easiest argument is to say, yeah, even the EMD, which is why if the seller insists on having this document, it's going to make their house a lot harder to sell, right? Because buyers are going to be pretty annoyed. Say, hey, we're not even getting underway until you potentially close on a new house. They might not be willing to wait and sort of forego other opportunities. Yeah, that's how I feel, Cynthia. Okay. Let's hop to, okay, so there are 3 documents here. that are notices. So we know that for your property inspections addendum, we have a PIN, the property inspections notice. That is the document that we use to sort of effectuate the negotiations, send the documents back and forth, right? But the property inspections addendum only contemplates certain things: structural, mechanical, mold, environmental, etc. There have always been a few extra ones, such as septic, such as water quality, such as water yield, where we didn't really have a friendly way to negotiate how that was going to be handled, right? So now MAR has created essentially a PIN for each of these unique inspections. So let me show you what they look like. It's basically identical to the PIN, but there's three of them, right? So this one is for the OSDS, this is for water quality, this is for water yield. So you get it done, you either say, yeah, we're great, let's move forward, or tests are not satisfactory, here's a copy of the report, I would like X to be done, if they don't do X, you can then terminate. And interestingly, there's a lot less flexibility with these ones, because perhaps they're a little bit less comprehensive relative to the property inspections addendum. But you either, the seller either fixes it or they don't. There's generally not a lot of like back and forth, or at least this document doesn't really contemplate, hey, I'll partially fix it, hey, I'll fix this, but not this. So it's same thing, kind of goes back and forth. You get to decide if you're going to cancel. Yes, Ms. Wheeler.
Isn't there a specific line in the original pay notice or property inspection addendum that states that the buyer can only put forward one single written request? And
For that inspection.
right, but these inspections are going to be noted on the EIA, right? The property inspection addendum, hey, I'm having on-site well and septic inspected. Or are these are tying to the separate addendums you're saying?
Correct. So you would have, so I actually probably wouldn't necessarily reference, for instance, water yield in the property inspections addendum, because I'm going to have a separate water yield addendum that's
Okay.
also attached.
Okay.
So,
So in the other like additional inspections area, you wouldn't say, well, septic, whatever, because we have the specialty addendum already noted in the contract. Because now we're gonna be putting forward like.
right. I mean, my intuition is, yeah, go ahead and throw it on, but you've identified, it could potentially raise a conflict that, hey, now you're asking us, then asking us again, and asking us again.
Right.
So maybe I think I would not reference these specifically on the property inspections, note it or addendum, limit it to, the normal ones there. And you can still have the other category for, pool inspections, or you could put other as recommended, with the understanding that water quality, water yield, and septic are still going to be their own addendum with their own sort of timelines and process for requesting repairs. So hopefully this will make life a little bit easier if you have those sort of specialty inspections done. It just provides a more formal way to go back and forth and make sure everybody is protected. Okay, those are all the new forms. Now we have the revised forms, some of which are responding to new laws that were actually pretty important that are going to impact our day-to-day. And I'm going to have to go a little bit faster than I'm going. Okay, the consumer notice to buyers of residential real estate in Maryland. If you are not already using this document, please start using this document. Should always be included with an exclusive buyer-tenant representation agreement. Whenever you'd have a buyer representation agreement, make sure you include this consumer notice. The consumer notice is here to protect you. So we're giving them a heads up, hey, all this weird stuff could happen, and they're signing it, so they're less likely to come after us if something bad happens. Okay. House Bill 107 requires condos and HOAs to do reserve studies to make sure that their institutions are properly funded. Does anyone remember, it was a couple of years ago, there was a condo that collapsed in Florida, like 98 people died. It was this
Mhm.
catastrophe, right? Where it basically said, hey, was this property built to code? And also, were they adequately funded to make the repairs that they needed to make? So now this became basically a public safety issue where we're not just going to leave it to these HOA and condo people who just said, $100 a month seems reasonable, we'll probably be fine. Now they are required, as of this week, to do a reserve study where a structural engineer comes in and says, over the next 20 or 40 years, you better have X in your budget because you have a 30-year roof that's 20 years old. So you're going to need X amount to fund that. Your boiler's going to go up. You're going to need to repave your parking lot, all that stuff. Okay. So it's a financial tool to make sure that people aren't going to be scrambling and suddenly have to do these special assessments and all this stuff. So as a public safety policy and certainty of your own budget as buyers, this is great going forward. The problem is, this is going to be kind of a mess for the next 3 years. There are smaller condos and HOAs that maybe haven't done a reserve study because they didn't think they needed one. Now suddenly they do need one. Not only do they need one, it has to be funded by statute. If there's a cap in their HOA or condo association that says, we're not going to raise fees without being voted on, those caps are thrown out. By statute, they have to raise the money. Okay? So there's going to be people that maybe weren't being financially prudent previously, that suddenly they're going to realize, oh, we need $800,000 in the next 3 years. Guess what that means? It means increasing your fees, and a whole bunch of special assessments are going to start coming down the pike. So this basically is a notice. Hey, condos are doing this now. Buyer is advised to pay close attention to the reserve study report, as an underfunded study may result in future increase in condo fees, HOA fees, and the imposition of special assessments by the buyer. These reports are going to be included in your resale packages going forward. So just encourage them to look at them. And you can sometimes basically do the math, like, oh, they're this far behind and they're only collecting this much. Like, you can basically sort of project that, oh, they're about to have a special assessment, or this is going to be a big problem. This is also going to have big lender implications. I was on a webinar where a lender sat in and said, we now have to look at this report. If we see that they are structurally underfunded, or let's say the inspector came in and identified critical repairs, they cannot lend on that institution until they take care of that stuff. So there's going to be loans falling through, and there's going to be a greater number of assessments coming forward. So this is a CYA. Your buyers are signing this. They have been informed about this. They will get copies of this in their resale packages, okay? But it's something to at least have a very basic understanding of what's happening so that we can be responsive as people have questions.
There's no database, like a central database for these kind of associations, almost like with FHA, inmate approved condos. Like, there's not a list of condos that have done reserve studies.
There is not.
And they're not creating that.
Not to my knowledge. They had somebody from like the Maryland Attorney General's office who's basically in charge of enforcing this. And that question was asked, and I said, yeah, we really don't have this. I don't know if we can have this. So it's gonna be a little bit of a mess, but going forward, this is gonna be great, right? Like, imagine if everybody is properly funded, special assessments should almost be a thing of the past, right? So buyers, when they buy into these, should have a lot more certainty of their budget on a monthly basis. But we're in a little bit of a transition.
It's gonna crush their values.
Well, it'll crush their values for the people that weren't doing the right thing.
Right.
So the people that have been financially prudent, maybe the bigger guys that are more responsibly handling the investment, they're not gonna feel anything.
Right.
It's the people that have.
Quick question.
Yeah.
Say, condominium reserve study, say you got the seller, and they trying to sell their condo, and with this being in the contract, wouldn't that be a problem with you trying to sell your contract if y'all reserve is way low?
I would say,
It would probably could temporarily, possibly cost you the deal.
it could cost you the deal, but it could also cost people suing your seller if they don't disclose it, right? So the question is. The attorney,
How can it be fixed? Like you trying to sell your home and y'all condo reserve fee is very low and, say we got 8-unit condo, so now when I gotta run around and try to get everybody to put some money in the reserve.
I mean, yes, it's going to tank a couple of deals, for sure. It will. There's gonna be people that were really trying to get X amount. And now buyers are gonna look at it and be like, oh, I protected this monthly fee, but now it's gonna be here. I'm not paying that anymore. So you can still sell it,
Yeah, you gonna have to drop.
just not for as much, right? You could say, look, if this is the monthly fee that I was expecting, it's not the buyer's fault. The condo associations were basically being, negligent with their fiduciary duties, basically. So, but yeah, there's some sellers that are gonna feel pretty screwed. That's suddenly like, big government stepped in, now this oversight is causing me all this grief. Statute is what the statute is. So then the question is, if the seller knows about it, if they know there's a special assessment coming down the pike, do they have to disclose it? I think the MAR attorneys strongly implied the answer is yes, for their own risk mitigation. And you as a realtor, if you learn that, guess what? That is a material fact that you need to disclose to protect your license. So it's a great question. I think it's going to make life a little bit challenging.
Sellers to get the package before listing a property. That way you're aware of it going in.
Or at the very least, there in the statute, I believe there's a right for the owners to get a copy of the funding reserve.
Right.
So yeah, I would have them get that copy, once you get the listing, you're like, hey, shoot them an email so you can get a copy of the funding just to see if that's gonna be a mess.
Everybody can have them working when you.
Yeah, exactly. Yeah, right. If it's just gonna be flagged by the lender and let a no-go to begin with. Okay, here's the actual big thing that I'm gonna take basically the rest of the 15 minutes. The state of Maryland has finally changed the way that we distribute earnest money as escrow agents. So the old method, and will still be used in some cases, is that the brokerage or the title company isn't releasing anything unless I get a piece of paper where both parties sign, you can release, then they're good. I think we've all seen instances where that has resulted in a non-equitable environment where the seller basically says, well, even though they terminated due to a proper contingency, F those guys, I'm not signing it, I'm just holding this money hostage. So that's something that the state has stepped in certain situations.
Wasn't what was unilateral with the school?
Well, you could unilaterally terminate the
Yeah.
contract, you could never unilaterally distribute earnest money. Earnest money always required two-party consent. Okay. But now, if the buyer terminates pursuant to a contingency, as defined by section 10-803A2, and that is important for reasons I will go into, the buyer may request the return of deposit by written notice to the escrow agent and the seller. The escrow agent has to return it back to the buyer within 10 days. Unless the seller delivers a written request for mediation that is notarized and they deliver it to the escrow agent within those 10 days. So it is like mess or get off the pot for the seller. They can't just drag their feet and say, hey, I'm mad, I don't want to sign it. If they're mad, okay, file for mediation. Okay, get that notarized and get it to me. Otherwise, the money's going back to the buyer. Okay, so this is a big change. So if you are a buyer and you terminate due to one of these contingencies, that day I'm sending a request in for that money. That starts the clock, tick, 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 tick. The seller then has 10 days to like, oh crap, how mad am I? Is it worth the $450 to go to mediation? Is it really worth it? Is it really worth it? Because as escrow agent, if I get a letter from the seller on the 11th day, I don't care. The 10-day deadline pass, I have to give it to the buyer. Okay, these deadlines are important. But if I do get that protest from the seller that's notarized, like, we can't touch it, right? Okay, this is now a matter for mediation. Come to some mutual consent, get a mediation order, go to court. I can't distribute it. Now I was, I'm a lawyer, so when I see, contingency as defined, it doesn't say if the buyer terminates due to a contingency. There's fine print. It's like, okay, crap. So now I have to actually read the blah, blah, blah. So, okay, let's go to A2. Contract for terminate due to contingency. Contingency includes as follows. No, this is a big list. This is 15 things. And it includes most of the big stuff, right? Home inspections, check. Appraisals, check. If you don't like the HOA, if you have HOA issues with the condo docs, short sale approval, all the fun notices that we just came up with the water and sewer and forest conservation, all that stuff. But then I was reading a little closer. So third-party approval not related to financing. Why did they carve out financing? Financing is not included in this list, you guys. If it terminates due to financing, the old method is still there, right? We need mutual consent. You do not get to take advantage of the magical expedited process, okay? This is something that in all the training materials, nobody mentions the carve out that it doesn't apply to financing. I had to consult the statute, go to the MAR hotline. They went to their congressional delegation that went to the congressional intent to look at the notes on the House floor, basically. And they're like, oh yeah, we actually carved that out on purpose. Financing was basically deemed too complicated for an escrow agent to sort of step in and say, okay, this is a clear-cut contingency violation. So again, this is a big, big, big change for most contingencies. But if the seller is terminating for any reason, or if the buyer is terminating for a reason that isn't one of these 15, the old method is still in place, right? So I'm a little bit nervous for other brokers and other title companies that might not understand. So maybe if you ask them for it, even with financing, they'll just send it to you because they don't know what the law is. But then they're potentially violating the Real Estate Brokers Act and could be some big problems. Are there any questions about that? That's if there's one takeaway, this is the one that's going to impact you day to day, guys. We need to make sure that we are explaining what to expect.
So when you say financing is not on that list, and say the buyer gets a letter denying a loan, they send it out, and the seller refuses to sign, that doesn't fall under this, under the release, if the
It does
seller-
not, right, so that would be,
Old law required.
yeah, so that would be, it's a contingency for the purpose of the contract. So you can get out of the contract because you have a denial letter if it was contingent on financing. But for the purpose of this expedited EMD release, contingency means other stuff. It doesn't mean financing. So in that world, you can still get out of the contract, you can still ask for a release of deposit, but title companies and brokerages are not releasing it unless there's a mutual release. Any other questions about that guy? Okay, this is the only one that you guys are really going to care about. It's not going to impact most of you. Brokerage agreements can no longer last more than 1 year in duration. Okay, most people weren't doing that anyway. Just for context, there was some funny business going on nationally where, let's say a builder sells you a house, but then they say, oh, by the way, you have to sign this 20-year listing agreement where if you sell it, you have to use us, sort of a thing. So there was some weird.
That sounds illegal anyway. That sounds illegal anyway.
Well,
Tie-in agreement.
it's a what agreement?
Tie-in agreement.
Well, anyway, this makes it clear. So it's a responding to a public backlash about that. So And the important part here, guys, where you could get yourself into trouble. This even includes continuances. So right here in paragraph 4, cannot be longer than 1 year duration. Okay, that part's pretty clear. Says, hey, you can extend this if you want, but if in no event shall the term, including any extension, go beyond 1 year. You need a new brokerage agreement. So if you start 1 year, you can't just tack on an addendum. You need a brand new agreement. If you have a 6-month term, you can extend it once, maybe to that full year, but you cannot ever exceed 1 year for one agreement. So it's just kind of an annoying paperwork thing where you need multiple listing agreements. So don't do that.
It don't take you that long to sell it.
Well, that's true too. Well, but it's also for buyers, right? So I think we've all seen buyers that maybe do take longer than a year. The lease changed very slightly. Now there is a pet protection during eviction paragraph that's been added, so pets can be protected. If you're doing any rent backs, guys, the post-settlement occupancy agreement has been changed to include just an actual time when people are leaving.
Settlement.
So it's like, okay, I'm gonna leave on the 5th. There's apparently a lot of back and forth, like where people schedule moving trucks and they're ready to move in at noon, but actually they thought they had until midnight. And since this is actually totally separate from the contract, there aren't really any definitions of what constitutes a day. So hopefully that will make people's lives a little bit easier. And then the final change is just the for selling any land. They added a contingency where you can get out of it if it can't connect to public sewage. So they just added in one little paragraph here. See, there's a whole bunch of contingencies. If you can't do X, I get out of it. So you can decide if it's also contingent now on the property being able to connect to public sewer. And COVID is over, guys. Apparently, the COVID addenda are formally retired. Now that I've said that out loud, I'm sure they will be back in short order. But for now, we're in good shape. So how does everybody feel? Not as terrifying as last year. It is not as terrifying as last year.
Can you share the PowerPoint?
Yes, I will share the PowerPoint. And I also created a beautiful infographic, which I wasn't sure I knew how to do and apparently don't know how to display. But basically, there's really only a few things that we care about. If we care about the deposit procedure, right? If you terminate due to a contingency as divided by, then you can get it back to your buyer pretty easily. You can't have a listing or a brokerage agreement go longer than a year. If you're dealing with an HOA or a condo, make sure that they sign the consumer notice and make sure you at least say the words like reserve study, special assessments, so that you can kind of have that conversation. And the couple of new addenda that will impact potential sellers, the Forest Conservation Act and the FERPA addendum. Again, only if it's a foreign person or only if there is a forest conservation plan. So really no, but these trigger really important rights that need to be disclosed.
I think this was applicable by selling.
Yeah, so if they are a foreign person as defined by the IRS, you need to put in the FERPA addendum, and if it is subject to a forest conservation plan, then there's a new addendum that you need to disclose as well. But that's only for like big properties where they subdivide it and there's the government stepped in and put them on some land.
Which one of these was the gun that you said gotta go to the agents agreement? Need to have an agent what's it consumed?
Oh,
Right,
yeah, so it was tied to the condo reserves where that was the document that was updated. It's the consumer notice something.
The consumer knows the buyer and seller.
Consumer notice to buyers and sellers. So this is a required form for every buyer or tenant brokerage agreement. And again, this is all just CYA stuff, right? There's nothing to fill out. This is just, if something pops up later, it's a protection for us, right? To say like, you signed the notice, like, you know, there's potentially some issues that come up commonly.
So the one is just tied to assuming notice to buyer to seller, and this is what, assuming notice to what?
So this is the consumer notice to buyers and sellers, but they just added a paragraph to say like, hey, there's some messed up
Oh, they-
stuff going on with
they-
condos and HOAs. So all they did was add something to this notice.
Or?
Yeah.
So it's nothing, a new addendum,
No, just
updated.
Just updated this one. Yeah.
Okay.
Yes, Mr. Lee.
For the earnest money deposit, it didn't used to be a requirement that the escrow agreement needed to be signed instead of being held by a brokerage.
It's still not. That's a great question. So the,
So how is the seller made aware of these timelines in the contract when it's held? by a brokerage?
it's subtle. The contract, which I don't even have here, like, there's a sentence that references the new law. So you
Okay.
basically just have to know the
Like
new law.
on the first page where it says where earnest money is held? Is it on-
Yes, so like, yeah, so when they're talking about the deposit release in the contract itself, they like added
That one?
half a sentence at the bottom.
Okay.
But the only way to get to, if you want to review the language, that's in the escrow agreement. So this is where you can get the bulk. This is your review material. If you have questions about it, you go to the escrow agreement. But it applies to, it doesn't matter if you're a broker, it doesn't matter if you're a title company. This applies to all escrow agents, as far as how this release is going to be handled.
Hey Doug, I have a question.
Yes, real quick, you have 1 minute.
Sorry, yeah. So is there another, because right now the request for the return of the deposit has to be signed by buyer and seller. Is there another addendum that they have that just has room for the buyer's signature so that to send over like a notice, or do you have to just type up a notice on your own and have the buyer sign?
There's nothing that I know of. I think it's good enough to just type an email saying, give me the money.
Okay.
I think that starts the timeline, but just make sure, because it does say that it needs to be provided both to the escrow agent and the seller, just to start that time frame.
Doug, for the mixed use properties, use the commercial one that they have now, or we can still use the residential, the first one that you were talking about. Buyer agents.
The brokerage agreements, we'll have to talk about it on a case by case situation. If it has a commercial component,
Right.
that's generally going to require an attorney to draft some amount of the documents. I don't,
Oh,
yeah, we'll talk about it on that case by case. All right,
Okay,
thank you. We have to wrap it here. Have a wonderful day. Thanks.
Doug, could you please send the pretty sheet that you created to us?
Yes, I will absolutely do that. Thank you, guys.
So much appreciated.
Nope.